8:15 on Newstalk Breakfast. Well, we're in the final furlong, of course, because with the moratorium on Thursday for broadcast debates on the referenda, tomorrow we'll be dealing with the Senate debate in our political panel, but today we want to deal with the Court of Appeal's referendum. If the referendum is passed, a new court will be set up between the High Court and the Supreme Court. The aim of the proposed change is to clear the backlog of cases currently waiting to be heard in the legal system. The referendum on Court of Appeal also contains a proposal to change how the Supreme Court gives its decision in certain cases. The proposed abolition of the one judgment rule would mean Supreme Court judges will be able to give individual reasoning behind their rulings. To debate the issue at hand, we're joined by two members of the legal profession, Paul Anthony McDermott, constitutional lawyer, and Stuart Gilhooley, solicitor and junior vice president of the Law Society. Gentlemen, you're both welcome to studio. Paul Anthony, your views, how you're going to vote in relation to the Court of Appeal referendum?
Well, I have to accept everybody in Ireland says it's a good thing, all the political parties, all the judges. I naturally get suspicious when everybody says this is a good thing and you have to do it. There's no choice. A bit like the night of the bank guarantee. I think some critical thinking needs to be brought to it. And if you were running a business and it was inefficient, it would be surprising if the answer you were given was, let's have another layer of complexity. Normally the way to speed things up and make them cheaper is to make them leaner. And I just think from my experience of law, the more layers you introduce in a system and the more courts you have and the more judges you have, the more court cases there'll be, the more delays there'll be. This isn't going to solve the problem, which is that Irish people are very litigious. For all that people moan about legal fees and delays, the reason they exist is because Irish people sometimes cannot solve their problems without a long court case.
And Paul, do you believe that the Supreme Court should just be made to work harder to clear the backlog or appoint more Supreme Court judges? Is that the solution you're offering? Because the backlog does exist. I think everyone agrees with that.
It does, but the real question is, should we spend 3 million on a complex new court which involves changing multiple articles in the Constitution, inserting complex provisions, one of which is 160 words long, and I simply cannot understand it no matter how many times I read it. Some of the provisions being put in the Constitution are going to be there for a year and then disappear. So we literally are ripping apart the structure of the Constitution in circumstances where nobody seems to have said, right, there's a 5-year waiting list. Let's see if we can solve it by putting more judges on the Supreme Court, getting them to sit longer, getting them to sit through vacations. Why is the first solution, let's set up a whole different court?
Stuart Gilhooley, you're in favour of this proposed amendment. Why?
Yes, I am, Ivan, and I think you'll find, and I'm sure Paul Anthony himself is half in favour of himself. I think he's admitted that. I think you'll find that nearly every lawyer that you'll speak to is in favour. The cold hard facts are this, is that in last year, in 2012, 258 cases were dealt with at the Supreme Court. If we compare this to jurisdictions around the world, if you compare it to the United States, which dealt with just 64 cases last year, in London the equivalent dealt with 77 cases, and in Canada 83 cases, and that is less than a third of all the cases that our Supreme Court is being asked to handle. And obviously, as you can imagine, the Irish court system, no matter how litigious we are, deal with a lot less cases than, say, the United States or England. So we're asking our Supreme Court to work incredibly hard. What we're also saying to them is, we want you to get through a whole lot of cases, so it's inevitable that the quality must drop a little bit. I mean, I can tell you that I've been at the Supreme Court on a number of occasions, as has Paul Anthony, and I've also had the pleasure of seeing some of these judges appear as barristers, and I can tell you this, that they are the cream of the legal profession, some of the brightest people in Ireland, but we're asking them to work like cart horses. If you ask Leon and Messi to play 200 games a year, the quality is going to drop eventually.
Do you think within the legal system, say I have a civil case and I lose it in the High Court, and I'm really upset about this, if I can paralyse a thing for 4 years, I'll actually sport an appeal to the Supreme Court just to paralyse the case. Do you think that's happening?
I think it's been known to happen, Ivan, yes. I don't think it's probably as prevalent as people think it is, but I think it's been known to happen. I mean, bear in mind, but by doing such a thing, you are actually putting yourself at risk of more costs. So I'm not sure that necessarily happens as much as people say it does, but I do think it happens, and I think that's one of the reasons why we can't have a situation where people are having to wait nearly half a decade to get their cases on.
Paul Anthony, I put it to you that this deals with civil matters. In the criminal court structure, they introduced the Criminal Court of Appeal, which is a parallel to this proposal. Surely, has it worked, or do you feel it hasn't worked?
Well, of course, it has its own delays, and notoriously the Court of Criminal Appeal, it can take years to get your appeal on. And we've seen examples of recent cases where the DPP has appealed the leniency of somebody's sentence. By the time the appeal gets on, the person has already been released, and the Court of Criminal Appeal is faced with the unenviable task of deciding, are we going to pull the person back into prison and say, sorry for releasing you, we meant to give you a longer sentence? So I think that actually proves that just by creating a new layer of courts, you don't solve the problem of delays.
But surely it allows a filter whereby those cases of genuine constitutional points or points of public interest can go still to the Supreme Court, and all the rest on points of law can be dealt with by the... Is it not a clearinghouse as such?
It is, and it certainly means the Supreme Court will now be able to pick and choose the cases it finds interesting and the cases it would like to hear, and all of the boring, less important cases will be dealt with elsewhere. I think that will reduce access to the Supreme Court. One of the great things at the moment is, no matter how humble you are, even if you're a lay litigant, if you lose in the High Court, you can go to the greatest court in the land. And if you go into the Supreme Court, particularly on a Friday when cases are called over, you see ordinary members of the public, not legally represented, able to stand in front of the Chief Justice and say, I want justice. I want my appeal heard. So it is this incredible system where if you go into the US Supreme Court, there'll be people there with guns, guards. Ordinary members of the public aren't going to be able to walk up within a couple of yards of the US Chief Justice. In Ireland, people can do that. Now, after this, none of that is going to happen. The Supreme Court will take the posh cases, the interesting cases, the cases that have media attention, and all of the boring cases are going to be dealt with at a lower level. And that will mean for most people, you will never get your case to the highest court in the land.
Stuart, the other change here, it's not just a one-topic referendum, it's the one judgment rule. Do you favour that? I mean, what you're going to have now is, you know, all the sum of the parts as such.
Yeah, I mean, I suppose it's a little bit strange that they're put in together and we don't get an opportunity to be asked to vote on the two of them separately. But yes, I do, is the answer to that. I do favour it. I see no reason why, if a judge is being asked for their view on a case, that they shouldn't be entitled to provide a dissenting judgment, which is essentially what this proposal now allows. I think, again, in most common law jurisdictions around the world, if a judge on a weighty constitutional matter has a different opinion, they're entitled to express that view, and we're entitled to see what that is, because it doesn't necessarily mean that just because a majority thinks that's what it is, that's necessarily the right view and that will stand the test of time. So dissenting judgments can be very important.
On that point, Paul Anthony, do you favour the change on the one judgment rule?
No, we're being asked to introduce a Court of Appeal so the Supreme Court can do less work. Abolishing the one judgment rule means they want to do more work. The reason we have it is to protect the judges. Imagine one of the pieces of emergency financial legislation introduced in dramatic circumstances in the last 2 years. If the Supreme Court had struck down one of those acts, there would have been incredible political controversy. A government could have fallen. The Supreme Court was able to rule on them anonymously, effectively. You don't know which judge voted which way. A bit like in a jury, do you necessarily want to know, the accused person to know, you were the one who persuaded everybody they were guilty, or you were the one who persuaded everybody to acquit? So having it anonymous where the Supreme Court issues a single judgment protects the independence of the judges.
OK, I'll put this final text to you, Stuart, as a proponent of the referendum, from Dave in Dublin. Simple solution. Take less holidays. In any other business, holidays are there to suit the needs of the business. In my job, if work is piling up, I work later and longer.
Yeah, I think that's very unfair on the judges. I think that's a little bit like saying that you guys only work 2 or 3 hours a day. And the reality is, of course, is that they're spending an awful lot of time doing judgments and spending a huge amount of research doing up lengthy judgments, which require a lot of time. I can assure you that I know for a fact that most of the Supreme Court judges are working this September. So they do get holidays, they do get long holidays, but I can assure you they're working the rest of the time. OK, that was Stuart Gilhooley, Solicitor and Junior Vice President of the Law Society. And before that, you heard Paul Anthony McDermott, Constitutional Lawyer. Thank you both, gentlemen, for coming into studio. Your verdict is now required, listeners, on Friday on this topic. That concludes our debate on it.